All right, so let's roll right into our next panel here. This is a three-part panel. I'm going to keep the introductions very short and tight so that these panelists can speak. And our first panel has Chris Griswold, who's up on the stage right now, Policy Director at the American Compass and a Lewis O. Kelso Research Fellow at the Rutgers University School of Management and Labor Relations, graduate of Wheaton and Princeton Theological Seminary. All right, and with him is what's your name? A man who needs no introduction. My former professor and everybody's current professor, Sam Estreicher.
Thank you. I want to say a word about the American Compass organization. I was at an event this past week. The American Compass organization is a conservative organization that is actually very much concerned with American workers and the American working people. So it's a very interesting organization. I heard some terrific talks by the Secretary of State and the Vice President, and they're going to be a major force in the Republican Party. There's no question about it. So look out for the American Compass and Chris Griswold as well. Okay. So we're going to be talking about, America First workforce policy and the topic near my heart, sustainable labor law reform. We're going to start first with Chris.
I'm just so intimidated to be the alternative to break. That's a terrible position to be in. Morning, thanks for having me. It's a delight to be here, in part because my colleagues and I have spent the last few years trying to convince people that a conservative embrace of pro-worker, pro-labor economics is a real thing that can and does exist. And so it's great to be with Professor Estreicher, who knows that it exists. That's a real evolution and advancement, and it's encouraging. Just to put some data points on the board, Sean O'Brien, the Teamsters Union president, spoke at the Republican National Convention last year, as we all saw. We have a Teamsters endorsed labor secretary who's a self-described labor advocate. As Professor says, you mentioned the Republican senator who walked picket lines is now the vice president, and the Republican senator who endorsed the Amazon unionization drive in Bessemer is now the Secretary of State. A leading Republican senator, Josh Hawley, is working with organized labor to distill elements of the PRO Act into a conservative pro-labor framework. That is all, in my mind, incredibly encouraging because, Professor, as you said, cards on the table. American Compass, the organization that I work for, has been at the forefront of advocating a pro-worker conservatism and has supported and, in fact, instigated a lot of the changes that we're seeing. So I'm here kind of as a fully committed partisan on one side of that debate. And maybe as a little unusually for a conference like this, I want to start by offering my own perspective on the philosophical underpinnings of like what's animating that shift. And then we could talk about some of the policy opportunities that opens up. So a quick view, I guess, of the animating principles driving some of this change is a self-conscious rejection of the hostility to collective worker voice and power that's long been associated with the political right of center. It's a self-conscious desire to supplant the free market fundamentalism that has dominated Republican economic policymaking for a long time. And that obviously has implication, that broad kind of post-neoliberal impulse has implications across the policy spectrum, including globalization, for example, whether or not the optimal tariff rate is in fact zero. But specifically on the question of labor, I think there's a very simple premise that underlies a lot of this thinking, what I would call the new conservative thinking on labor, which is that workers are human beings, not just production inputs, not just factors of production, and policy needs to treat them accordingly. That, I assume, is uncontroversial and self-evident. No one in the room would disagree with that, but it seems to me that if you sit with that premise for long enough, it starts to have some pretty profound, not just moral and civic implications, but policy implications as well. Starting on the moral level, even a basic attention to the preconditions of human flourishing requires respect for the sense of agency and voice that workers want, but generally do not feel like they have in the American workplace. Tom Cochin at MIT does amazing polling on this. If you don't know his work, I encourage you to look it up. And he's polled on what he calls the voice gap, which is the yawning gulf between the influence American workers say they want at work and the influence they say they do have at work. And not just on compensation and benefits, but also job security and their employers' values, the implementation of new technology, and so on. Our own polling at American Compass shows that job satisfaction is highly, highly correlated with whether or not you feel you have influence in your workplace. And I mean, that is in fact more determinative of job satisfaction than objective things like working conditions, which was a finding that shocked me. That's how deeply rooted the desire for agency and voice in the workplace is. And politics, I think, ignores that at its peril. And just a side note, I know we're not here to talk about the future of democracy, but the future of democracy is relevant here, I think, because the experience of being economically disenfranchised in violation of your own sense of human dignity has obviously threatening implications for the health of American social fabric. The best expounder of this point in the 20th century was probably Martin Luther King Jr., who was very, very clear that without economic participation and a sense of economic agency, the viability of the American democratic project was threatened and would ultimately fail. And I think one way to summarize what is happening is that a lot of conservative thinkers and leaders and politicians have awoken to the fact that this is how the American working public feels and what they want. Economically, the implication of the fact that people are not created for the purpose of selling their labor means that the labor market works differently than other markets. The supply of labor is not correlated to demand in the same way as other markets. How and where the labor market clears has moral and societal and political implications that we have to care about. We can't be indifferent to that. And I guess the last philosophical point I would make is that if we agree that we can't be indifferent to those outcomes, what are the mechanisms for addressing them? Well, you can do that through regulation, and there are certainly cases where that's the correct modality to address a concern. But if you want a place for free market dynamics to have a say, which I think all conservatives and most Americans do, then you need mechanisms for collective worker voice and power. And that is the counterintuitive impulse that is, I think, shaping the emerging conservative pro-worker agenda, is that the free exchange of price signals on which a healthy free market dynamic depends requires that workers have the capacity to speak collectively, not just individually. And I'm very, very fond of reminding my libertarian friends that Adam Smith knew this. This is my favorite quote from Adam Smith. "Upon all ordinary occasions, employers have the advantage in the dispute and force workmen into a compliance with their terms." And the reason he thought that is that workers can't hold out as long on their own as employers can, generally speaking. John Stuart Mill, beloved of libertarians, even better quote, "The laborer in an isolated condition, unable to hold out even against a single employer, will as a rule find his wages kept down, while workers sufficiently organized in unions may, under favorable circumstances, attain to the higher." And then he goes on to disparage the moral character of anyone who doesn't want to see workers attain to the higher level of wages through organization. Catholic social teaching has always understood this point. Some of the seminal conservative thinkers like Robert Nisbet understood that unions are supports of economic freedom, not constraints against it. And if this is true, if it is true that a precondition of genuine economic freedom in the market is the capacity for workers to speak together, well, then policy has to vouchsafe that. And that is a rejection of the libertarian assumptions that have driven Republican economic policy for a long time.
If I could just add to that, since you mentioned Catholic social teaching, Pope Leo XIII, not the current Pope, wrote about a just wage in Rerum Novarum, and so that's also embedded in Catholic social teaching.
One of my favorite quotes from Rerum Novarum is Pope Leo XIII talks about how justice demands that those, meaning the working class, those who contribute so much to the benefit of the community, have a right to enjoy the benefits they create, which is totally correct. So if that's kind of just, and we can talk as much as you like about kind of the political and philosophical dynamics here, but the policy implications of that, I think, run on two tracks. One is making the NLRA system work better for workers, and the other is offering an alternative vision of what American labor law could look like. On the first track, I think there is a remarkable focus on combating employer misconduct. Current enforcement, in my opinion, is laughable when it comes to unlawful union busting. And there's a rediscovery in the Republican Party that to be the so-called party of law and order is a sham unless you are also concerned about employer lawlessness, unless you include in the scope of your view what the employer community does. So one topic, and Professor, I know this is something you care about as well, that has risen in the interests of Republican lawmakers is the increased use of 10J injunctive relief to send a worker swiftly back to their workplace if they are fired for protected organizing activity, rather than wait a year or two for them to be reinstated on the back end, which is no disincentive to an employer at all. Even a document which must not be named, the Project 2025 document from the Heritage Foundation, even that document endorses the increased use of 10J injunctive relief. That's how deeply, I think, into the mindset of the American Right of Center this idea is penetrating. On the legislative side of things, as I mentioned, Senator Josh Hawley from Missouri is working with organized labor to take selected provisions of the PRO Act and offer them as a framework for increased worker rights. And this is a fascinating question. We did some polling on this. And one of the things I love about what Senator Hawley is doing is that he is calling the bluff on both sides of the aisle. Because when you poll American workers about these provisions, say, for example, in the PRO Act, they love some of them and don't love others. So, for example, the requirement to post labor rights in the workplace, that's 71% favorable across the board among Americans. It is 45% net favorable among Republicans. Increasing penalties for labor law violations, that's broadly favorable the public. It also has like 29% net favorability among Republicans. Expediting initial collective agreements, expediting first contracts, broadly favorable in the public, 19% net favorable among Republicans specifically. And then there's another set of provisions that Democrats have often advocated for that are widely unpopular with all workers, including disclosing personal contact information to unions, nullifying right-to-work laws, and then prohibiting captive audience meetings is somewhere in the middle. Card check is unpopular with everybody by dramatic margins. And it's interesting to see how that splits out, because you have a Republican leader asking himself, all right, well, how can I make the NLRA system work better for workers who want to exercise their right to unionize? And I think wisely mapping that on to what American workers actually want. Two notes on that poll is that working class respondents broadly agree with Republicans about which of those provisions they do and don't like. And then even more encouraging or dismaying, depending on your perspective, with respect to my elders in the room, those that I will call old Republicans, meaning those born after 1980, I regret to inform you, hold very traditionally anti-union views. But young Republicans born in 1980 or after are almost radically pro-union in their views. For example, on the question of increased penalties for employer misconduct, older Republicans split down the middle. Young Republicans are 42% net favorable to that idea. All right, so, and we can talk more about that if you like, but then on the more kind of forward-looking side, all right, like what if the NLRA model is no longer fit for purpose? What else could we do? Three things I want to mention very quickly. One is works councils and amending Section 882 of the NLRA, which forbids company unions. I think rightly so, but it also has the effect of prohibiting collaborative union management, non-union organizations, which workers say they want, again, by wide margins. The TEAM Act in the 1990s would have done that in a broadly pro-employer way, which I think was a mistake. Senators Rubio and Vance, while they were still senators, introduced a bill to do it in a much more equitable way and amend Section 882 to allow for collaborative, non-adversarial, non-bargaining organizations, collaborative organizations, if both a majority of workers and the employer want to do that. A little bit more spicy, something we've worked on, something Senator Vance has expressed interest in, and that's an emerging topic of conversation, is sectoral bargaining, and allowing representatives of labor and employers to set floors across industries. rather than kind of a workplace-by-workplace model. And especially when combined with works councils, as, say, the German model, for example, that elevates conflict out of the workplace. You can have a non-adversarial works councils for collaboration in the workplace, and then the hard bargaining happens at the industry level. And I think one of the things I love about that is that it solves a perverse incentive. It's immoral, I think, for employers to union bust, but it is rational for employers to do that if allowing a union or kind of failing to race to the bottom on wages places you at a competitive disadvantage. I get it. You can take that off the table by just setting floors across industries, which will then require the American corporate sector to compete on innovation or product quality or customer service, or all the things we actually do want it to compete on rather than a race to the bottom. And then very quickly, the last thing I'll mention that is of growing interest to folks on the right is the Ghent system in Europe, which allows unions or worker-controlled organizations to be in receipt of public and private funds and then administer worker benefits, including things not just like healthcare and training, but also unemployment insurance and other things that in the US are typically the purview of the state. And in those countries in Europe that do this, it has the effect of radically increasing transparency and accountability, which I think would be salutary in the American context, especially think of something like UI, which collapsed during the pandemic with no consequence. We polled folks on this, and Americans across class and party affiliation, if you ask them, what about this deal? If you prohibited unions from spending on politics but allowed them to be in receipt of government and employer funds and administer benefits, would you like that? And that's popular by 2-to-1 margins across the board. And one thing to note there too, one potential reason for the decline of organized labor in America is that they have less to do and that the value proposition has decreased. Union density in these countries is very high that use this system in part because the value proposition of belonging to a union is so great. I haven't mentioned the toxic effects of union involvement in politics. I'd be happy to talk about that. I think that's an important element of this question and helping rescue the labor movement from itself. But let me end there in the interest of time, and we can continue the conversation.
Thank you, Chris. As you can see, Chris and the American Compass organization are offering a kind of interesting new horizon. I don't agree with everything he says, but I agree with much of what he said. And this also bears on tariff policy, which maybe we'll discuss. I want to take my time to talk to you about proposals that I have called towards sustainable labor law reform. The way we do labor law right now is everything changes with every new administration. And we count on we used to have a filibuster system to induce compromise, but we rejected the filibuster system with respect to judicial nominations and with respect to executive nominations. I always thought filibuster made no sense with executive nominations. With judicial nominations, I think it does to some extent. These are lifetime jobs, but that ship has already sailed. I'm a little worried about the end of filibuster with respect to legislation, because then we'll end up in a South American-style republic. With each new party coming in, it'll change everything. Now, we see hints of this already with the NLRB's administration of the National Labor Relations Act, Department of Labor's administration. Things changing with each new administration. And we'll go back to square one. We're going back to square one on joint employer. And, there's no new thinking on joint employer. So I'm talking about sustainable labor law reform, because I do believe, not just the folks at American Compass is entreating, but I think there is a significant segment among American employers that actually want to see a fair labor law. That doesn't mean they're going to agree with everything that is in the PRO Act or everything that unions do, because not everything that unions do is desirable. But it means, I think, they see the value of the National Labor Relations Act. You'll hear later on Roger King, David Sherwin, and my view for a labor court proposal to try to save the NLRB. That's one reason I carried that placard with me when I had photographs with you, because if we don't have the NLRB, we're going to have, I think, a return to the law of the streets at the end of the day. And that is not desirable. I don't think it makes sense for most American employers to see the end of Taft-Hartley preemption, and to see recognitional picketing go on indefinitely, and to see secondary boycotts. I mean, I don't think they're thinking through what's good for the goose will also be good for the gander. So I have a set of proposals, and not everyone's going to agree with every one of them, but I just want to highlight them. One is with respect to card check. A very interesting finding. You say American workers don't like it. I don't like it either, even though I consider myself pro-union, because I don't think that's the way a union should get in, because it will involve getting a card in front of your face by a union organizer or a union supporter in the workforce. And I find that if someone wants me to sign something and they have some influence in my job, I'm going to sign. I'm just not going to be the brave one. I'm going to sign. And happily, that's what card check is in my view. So if we move to card check, I have an article in the Minnesota Law Review I'm glad to share with you, easy in, easy out. If we move to card check, because I know the labor movement wants easy in, hard out. In other words, you get in on card check and you can't get rid of the union as a practical matter. If the employer, the board law shows this, if the employer offers a token to the worker, that's going to invalidate the decertification petition. So it's got to be easy in, easy out. If the union comes in informally by card check, then when it's an appropriate time, in other words, when there's no longer a contract bar or all the other bars we have, then the workers should be able to do the same by card check. Now, this is not the law in Canada. Some of the provinces have adopted the PRO Act law, easy in, hard out. But if you want easy in, it seems to me, you have to have an informal means of decertifying the union. I'm not in favor of card check. I'm just saying that, and if you're going to have card check, there needs to be a waiting period so you can revoke your signature. I mean, you got to be honest with this situation. We've got a problem with the NLRB. We've got a problem with the lack of penalties, but card check is not the solution in my view. And nor is it the solution to have the kind of sectoral bargaining I hope you'll reconsider, where I believe in Uber and Lyft drivers having a right to engage in collective bargaining free of antitrust scrutiny. I've written about this. But to have a statewide, Massachusetts-wide unit for the union there, that means the union will never be accountable. My son-in-law is in a statewide corrections officer unit in New York State. The union is not accountable because it can never be held accountable in that kind of unit. So you need to think about that a little bit on sectoral bargaining. I do believe in secret ballot elections. Secret ballot elections is the safeguard of the labor law, in my view. Now, we need to strengthen secret ballot elections in a couple of ways, but I do believe in it. And I think most employers believe in it. If they believe in it, they have to also change some rules to make it a fair contest. And one change, I believe, is providing reasonable access to the union on the employer's property, using the employer's email system or whatever. We can work out the details. Once the union shows that it has a significant showing of interest among the workers, that could be by card check, by signature, and that sort of thing. The way we do it now or some other way, you get access to the workers. Now, it could be the kind of access that gets negotiated, that I'm familiar with, that Roger King and I have been working on with respect to healthcare bargaining units. Access where you actually have to come in on defined times, you sign in, and you don't have a right to roam the factory, but you have the right to talk to workers at the break room, in the cafeteria, without the employer there, in my view. No employer surveillance of that. I'm not in favor of captive audience speeches. I don't think they have that major impact, but there should be, in my view, a right of the workers to opt out of the captive audience speech, for sure. And I think we need to change the board rule. I think the board can do this now, to expand the rule it has with respect to mass assembly talks before the first, during the last 24 hours of the election, to extend that to a bar on captive audiences for a longer period. But I don't think that's that important, by the way. I just don't think it is. Because I think most workers resent the fact they have to go to a meeting and listen to BS from an employer. So I don't think it actually increases support for the company's position. Maybe companies feel differently about this. We can talk about that. There needs to be access, and I think we can do this. I think the board could do this on its own. It's simply an extension of the reasoning in Excelsior Underwear. Basically, the board and Excelsior Underwear, that's the case, the NLRB case that says you have a right to, the bargaining unit names and addresses. And I would include also email addresses today. Once you make a showing of interest, and the board said in that case, the union is no longer a stranger union because it's able to get signatures for 30% of the bargaining unit. They're going to be the electorate, and they have a right to be an informed electorate. That was what the board reasoned in Excelsior. I would use the same reasoning for access to the property. Again, it's got to be a kind of property where there's no right to roam the factory, roam the establishment, set times, set places. I think that would, first of all, that would show the union has some possibility of influencing working conditions in that plan, and also give the union a chance to counter the employer's lies. I want the employer to have a chance to counter the union's lies. That's one reason I believe in secret ballot elections. And I think this can be done under board authority, but it would really be strengthened if there was a statutory change here, and I hope you'll give me some access to the Republican senators so that I can convince them of this. And I think there's some interest, by the way, I really do. Ex-ante disclosure reform. Right now, we have lies from both sides, and that's no way to cast a vote. I know that's general politics, but unlike politics, you can close your, they don't really affect your livelihood that well, because we know in the United States, and I think the Federalist godfathers that we had indicated, let's have a government that can do very little. The truth is they can do very little, and so whatever lies are being vented, at the next time around, there'll be an election to oust them, and you'll get new lies, a new set of lies, and that's the political process. But here at the workplace, this employer and this union will affect my life. Every single day they will affect my life. And so I think we need to have more information given to the electorate. I think this can be done in a way that respects the need for confidential information. Let's start with the union. The union should tell every worker by internet access what their strike history is and the content of the contracts that they've negotiated. I think across the board, but we can say at least in that industry. And what their policy is on union discipline. My father couldn't believe it. He was in an absolutely, it was a sweetheart union, and sheet metal workers, I hope they're not still around, maybe they are, they want them to do picket duty. I mean, he hadn't heard from them ever. The employer wouldn't let my father, who had a bad back, have a chair. The union was not there, never to be seen. And by the way, that's also true of the union running the clerical workers here in this building. They come to me. I am actually the shop steward for the clerical workers here at NYU School of Law. Why? Because this teachers union has no interest in administering the contract. I'm not sure it's true of all teacher unions or every local, but that's the situation here. That's the situation for a lot of union workers. Okay, so I think there needs to be information about those things. I think there need to be statutory rights for workers if they're going to be in an exclusive bargaining relationship. They don't have to become union members. They should have a statutory right to vote on strike, on contract ratification, on union dues authorization. Those are Section 7 rights. If you want to become a union member, that's your business. See, I'm not a big believer in union democracy, even though I worked for a while for the fellow group called the Association of Union Democracy. Because the truth is, most working people don't have time to go to a union meeting on Sunday. I mean, they've been in this job the whole time and listen to something and have to know something about the Roberts Rules of Orders where they get manipulated into silence. So it's not union democracy. It is the right to have an opportunity to vote in secret on the key participational issues that I mentioned. They are whether to have a union, whether to retain that union, whether to have that contract, whether to have the strike. Those should all be statutory rights of union workers. You don't have to belong to a union. As far as I'm concerned, unions can be run by authoritarian dictators. In fact, they might be more effective. The Teamsters was run by authoritarians. It was a damn effective union. Why do I care whether they have union democracy? I just don't understand it. Historically, they were democratic organizations up to a point. But why do we have union democracy? We want effective unionism, accountable unionism. If they want to be democratic, that's their business. I give them every right to be democratic. But it's a shallow democracy. because people will not show up at these union meetings. They will not be sufficiently educated. They do not know the rules, Robert's Rules of Order. That's simply, they're just going to be manipulated. They know they're going to be manipulated at those meetings. They have to be manipulated at them. If you have, anyone's been truthful. All right, risk of retaliatory discharge, here we in total agreement. 10J has to be strengthened in a big way. I couldn't believe there was litigation where we are fighting 10J injunctions to find out whether the workers really believe there's a chilling effect. Well, whenever there's an area of deference to board expertise and experience, if you get fired, if it's a nationwide unit, okay, maybe you didn't hear about the discharge. But if you're in a unit of factory workers, say 100 factory workers, you heard about a discharge, there's a chilling effect. We don't need to bring experts in here to litigate whether there's a chilling effect. 10J should be made easier, and it also should be made harder in a certain sense. The board should not be able to get a 10J on the affidavit of union supporters. There should be a mini hearing. It could be a one-day hearing, it could be a two-day hearing, run by an ALJ. There needs to be a record as to why you need a 10J. And by the way, when the workers take over the plant and bring the media in, that is not a good case for a 10J in my view, and that's why you lose in the courts, because it's stupid. The NLRB has to be smart to get the respect of the courts. That was stupid. That's why you lost to the courts on the very standard for a 10J, because it made no sense to seek a 10J in that case. You guys know which case I'm referring to. Deterrence of bad faith bargaining. Here we're in agreement up to a point. First contract interest arbitration. I know this is something the Teamsters wants. The problem is it will not be first contract. You look at the Canadian experience, it also extends to renewal bargaining. And we go from liberty of contract, true liberty of contract, taking into account what J.S. Mill had to say, we go into some sort of like compulsory contracts. Now, who do you think the third-party arbitrator is going to be? There's no magic to this. The third-party arbitrator is going to be someone acceptable to the unions. And so you essentially have union-set contracts. Now, maybe you can change that, but I think that what we need to do is have a system that makes the unions also reasonable in what they are seeking. Anyway, but you do need to deter bad faith bargaining. How do we do it? Fines, litigation and negotiation fees for the union if there's bad faith bargaining. Have advisory arbitration. In other words, have an arbitrator say, well, this is, I think, a fair contract. Make it tripartite, if you will, whatever. And if the award is rejected by the employer, that should be an element in determining whether or not the employer has violated his good faith bargaining obligation. So I think there are things that can be done to make this a more significant system. I do believe American Compass and Senator Hawley have identified a serious problem. It can't be the case. You go through the struggle to get a union, and at the end of the day, you could be dickered around by the employer and there's no contract. That just can't be a realistic system. But I think there are things we can do short of interest arbitration. And if we do interest arbitration, we've got to make clear it's not renewal arbitration on that basis. It's final offer arbitration, and you have some say on who the arbitrators are, some sort of public screening of that. 882 reform is music to my ears. I gave testimony in the Dunlop Commission early in my career on 882 reform. It's the only place in the world, I would say, where you can't talk to your workers as a group to find out what's on their mind. Now, we talked about safety earlier from our friend from the Department of Labor. Well, yeah, you can have single workers talk about safety. The problem with single workers, you have the job over them. They're not going to speak, or they're not going to give you the full voice. So at the very least, let's start with these committees, allow these committees. Electromation makes no sense. The board decision, overturn it. Why isn't it on the list to be overturned? It makes no sense. You can't have bilateral discussions with groups of workers over things like smoking policy, over how they're going to deal with their waste, of absenteeism, covering for absenteeism. You're talking about treating workers like workers, and you can't talk to them. Why? Because we're worried about company unions. Well, company unions, I did my first paper at Cornell University for Alice Cook. She said, do a paper on the role of company unions in the formation of the CIO. At that time, I was really a radical lefty. I said, are you kidding, Professor Cook? Company unions are anathema to the CIO. Almost every one of the CIO unions was built on the backs of a company union. Why? Because the company solved the organization problem. The company organized these people, leaders emerged, they developed leadership skills, And when they felt they were jerked around, they went to the CIO. That's the history of the CIO, by the way. So I think things can be done to 882. I think the board can do stuff right now by getting rid of that election ruling, but maybe we need a statute to make it clear, and here we're in agreement. Unless the employee committee is being set up as an alternative to the union, that's how the workers see it, there should be no 882 violation. The public sector doesn't have this provision, the Railway Labor Act doesn't have this provision, and the European countries that we all love don't have this provision. It's time for 882 reform. The TEAM Act was too restrictive, I agree with that, although I supported it at the time, but I think it's a problem. Union democracy reform I've already referred to. DFR violations. If you want a union to be responsible, you have to. My first arbitration was, I was a union side lawyer for a while, and they gave me the right to sort of take a case to arbitration. It involved the bakery workers. I had 3 prep meetings with this person. Why? Because I didn't know what the hell I was doing, even though I was graduate of Columbia Law School and editor-in-chief of the Columbia Law Review and had clerked for a DC Circuit judge. I still didn't know what I was doing. And each time I had this prep session, a bunch of union heavies were there to accompany me. By heavies, I mean people like me of substantial girth. And I asked them, why? Because we thought he might pull a gun on you. He, the grievant. And why are they taking that case to arbitration? Why? Because they're worried about DFR litigation, damages. We should go back to the suggestion, and they could be SIPes, this can be done by the board, but it can also be helped by statute, that the remedy for DFR is re-arbitration. Why should the unfairly represented worker be in a different position than the fairly represented worker? Re-arbitration, but the grievant has to pick the arbitrator, have a veto over the arbitrator. I mean, you want unions to be responsible, you can't put that sort of Damocles in front of them. So that's something I think could be on our agendas together. Depoliticizing the NLRB process, we have a proposal on this. It's crazy. Every administration we change, the courts do not respect the NLRB. You know, they're going to vote, if they're Democratic appointees, they'll vote for the NLRB, but they don't respect it. They don't respect it because your policies are just based on who is the president of the United States. So we need to do something about this flip-flopping. I called it policy oscillation, by the way. I did not take out a trademark. I should have. I'd be a very, very wealthy man right now because it's constantly referred to. It makes no sense. Why would a court defer to you? Now, 90% of the cases the board decides are who did what to when, who, when, and where, and they get summarily affirmed by the courts of appeals. But every one of the big policy moves, everything that was on Jennifer Bluzzo's list, I love Jennifer Bluzzo, she's brilliant. Everything that's on her list, that's what's being contested. That's what's being contested. And I don't support what the current administration is doing. I think you've seen my piece, turning administrative agencies into puppets. For the president to say that the board members have to basically parrot his views on national labor policy makes no sense. I think it's inconsistent with statute. I think we agree on that as well. But you can't make new policy by just flip-flopping. Joint employer, what should be the rule on joint employer? We have the same verbal standards back and forth. It makes no sense. Where do we have a problem? We have a problem with insolvent subcontractors. That's where we have a problem, and a couple other places. Focus on the real problem and solve that real problem, rather than come up with these verbal tests, so that my good friend Dick Griffin, I don't know if he's here, we can litigate whether McDonald's is the employer of all the McDonald franchises. That's essentially what was done under the Obama administration. That doesn't make any sense. Now, Dick Griffin's a great lawyer. I'm not denying that. It doesn't make any sense. You can't have change in policy like this based simply on the policy preferences of the president. That's all I have.
All right, great. So before we have some panel oscillation, I'm going to see if we have any questions for these esteemed folks on the panel. And we have Mark Risk in the back. Do we have a microphone for Mark?
Hello, Mark. Mark is also a former student. You know, I take credit for all of my former students and people who are not my former students, if they're successes like Mark.
Mark Risk. But I'm self-employed, so I have no affiliation, really. I'm thrilled to have Chris Griswold here, and I just want to say that I follow closely your colleague, Oren Cass, who's everywhere now, but for the folks in this room, to me, he's one, as someone who approaches politics or American life out of a concern for the deterioration of work, the lives of working families, he's one of the most freshest, most interesting speakers in the country, and I commend everyone to him. And you've made an interesting case about why the conservative, the new conservatism is pro-union. And I've heard Orrin Cass made, and I've heard it. But let me ask you this: what's conservative about it? What's the difference between your agenda and, for lack of a better word, a Bernie Sanders agenda? And I ask that in a non-gotcha, serious way.
That's it. No, it's a fair question. I think a couple things. One, I'm trying to decide what order to offer my thoughts. I think a respect for the operations of the market is one place that I would start. The interest of conservative labor advocates, I don't think, is to try and overturn the functioning of the free market. It's to protect it and try and ensure that it works in a more optimal fashion. And I think that's a difference of mindset. I also think there's some difference in the kind of animating underlying motivations. One of the things, and this is actually one of the reasons I respectfully disagree with Professor Estreicher on the union democracy question, is that one of the things that has been lost with the decline of the labor movement is not just the ability of workers to advocate for their interests in the workplace. It is a civic and social fabric loss as well. Unions at one time were a site of civic and social life, of solidarity in the lived sense, not just in the theoretical sense or the economic sense. That is incredibly important. I mean, we were talking about Catholic social teaching earlier. There's a very, very beautiful quote from the late Pope John Paul II on how the social power of work is the power to form a community. And even if people unionize in the first instance to protect their economic interests, it also becomes constitutive of a healthy social order and of a healthy social fabric. I'm not saying Bernie Sanders disagrees with that, but I do think there's a difference in kind of an animating principle that brings us to the table. And one of the other things to say, I think, and this is maybe the most practical and immediate difference, and we didn't talk about this, but we should now, is union involvement in politics. It is, I would argue quite strongly, corrosive to the proper functioning of a healthy and robust labor movement to have the labor movement as politicized as it is. Our polling shows this, as does many other people's polling, that if you ask workers who are in a union what they like least about their union, it is politicking. If you ask workers who might otherwise be interested in a union but don't want to join, why? It's because of the perception of partisan politicking. If you ask people, what is it you want from your union? Bargaining on wages and conditions at the top, politicking is dead last, always. And there is a way in which, I mean, I was quite forceful earlier about the way in which the legal regime is hostile to organizing, and I think that's something the Republican Party has not acknowledged in the last several decades that it now is and needs to be. I think what the Democrats need to acknowledge is that the labor movement has in part politicized itself into irrelevance by being hostile to the political diversity of its members and potential members.
Can I ask you a question on that? Do you think that is worse in the private sector unions or the public sector unions?
You know, I think for the sake of time, let's just bracket the whole public sector union question and put it to one side, because it's, I think, such a specific question. Let's even just talking about private sector unions and putting public sector to one side. The reason that only 6% of private sector workers are union members that is a multiply determined outcome. Part of it's the legal regime. Part of it's other forces like globalization that diminish the power of bargaining power, and so on and so on. But part of it is the increased partisan affiliation of union leadership in contravention to, again, the political diversity of their own members. This is why the Teamsters Union declined to endorse a presidential candidate. It's because they asked their members what they thought. And a very decisive majority of Teamsters members supported President Trump. The organization obviously takes issue with some of the things the president has said on policy, so they couldn't endorse him, but they couldn't endorse his opponent in good faith because decisive majority of their members felt differently. So I think that question of the role of unions in politics is probably the stickiest and also most immediately sharp distinction between how a traditional Democratic lawmaker thinks of this, who in fact quite likely in office because of union support, and Republicans. And what's interesting is if you see some of the unions that are most forward-leaning on this and most willing to break out of their kind of silo and work with Republican lawmakers, it's organizations like the Teamsters who are willing to ratchet down their partisan noise in order to have a relationship with both parties, which is in their interests, and I think makes sense.
Okay, question in the back there?
Please identify yourself and your affiliation.
Hi, Professor Estreicher. You were my professor.
And I love- Thank you.
I'm Elizabeth Campbell. I'm at the National Labor Relations Board in the Division of Advice. I only speak for myself, though. But it's just a question, so I'm not really speaking on any policy issue. I'm curious about the card check proposals that you both mentioned. I think it's an interesting idea to be exclusively, secret ballot elections, but I'm wondering, what do you do about the truly, heinous pre-election unfair labor practice? I'm not talking about the couple of 8A1 low-level supervisor situation threats. I'm talking about, serious 8A3 terminations of lead union organizers. I'm talking about serious, statements by the CEO, we will shut down if you all unionize. So what do you do, in a close election loss in that situation? Rerun elections have been proven just not to work. The chill is done. And when you have a vast majority of employees before these, horrible unfair labor practices happen, having signed, I agree with you, Professor Estreicher, when you have a union organizer in front of you, it's maybe not the least biased signature you're ever going to make, but neither is that post-ULP secret ballot election. So what do you do in those situations?
Well, I think we have to have, as I said, strong 10Js. And it may need some statutory change, but they should be, if you preliminary get them quickly, we don't have to have all this paperwork generated by the board and or the general counsel. Build up some credibility with the district court judges and have interim reinstatement. Now, if we need to change the law to make clear interim reinstatement is not an extraordinary remedy, we should say that. And believe me, you'll take a lot of the profit out of that behavior. That behavior is unacceptable. You'll take a lot of the profit out of it. At the end of the day, however, the secret ballot election is the only way to make sure that the majority of these workers support the union. I am opposed to what the past administration did. If the election results should be stored, and I'm against the blocking charge. If you look at the duration of time, I did a piece on this. The really long cases where it takes a long time between the election and ultimate resolution are cases where unions have filed blocking charges. And I'll show you that this is based on NLRB data. The blocking charge doesn't make any sense. You think there's an unfair labor practice, it's been charged. First, hold the election, store the results of that election, and then adjudicate the unfair labor practice. Right now, there's a strong incentive in elections that you think have been lost to file ULP charges. So I believe in elections generally. I mean, general shoe is a big part. It's been forgotten by the NLRB. But the remedy of re-elections in some cases does make sense if it's done quickly. So 10J reform, serious general shoe action. So basically get rid of the blocking charge, in my view. Allow the election results to be restored. That'll take a lot of the profit out of filing these charges in the first place. It's an election bar of 1 year, and the bar doesn't hold if it's an invalid election. I mean, there are remedies in the law currently, and it's true, there are unscrupulous employers, and we need to maybe add some fining authority to 8A3. I'm in favor of that. We talked about that, not just in the election context. You have to take some of the profit out of it for employers, for unscrupulous employers.
All right, thank you very much. Let's have a hand for the panel.
Thank you.